Hi everybody, welcome to Talking Automotive with Mark and John. My name is John Sinclair and my co-host Mark Palavestra.
Hi John. Yes, today's episode I'm really keen to get into the meaty bits because we cover off the legal side of the franchising code of conduct and the franchise agreements.
Yeah, Mark, really great speaker. We've got Paul Kirton. He's a director from Macpherson Kelley, nearly 30 years experience working with him. Really good in-depth knowledge of the subject, and he brings across some really great points and things that dealers and OEMs need to be mindful of in putting their agreements together.
Yeah, Paul really covers off some really important stuff around the franchising code of conduct, the outcome of the ACCC and the Royal Commission, and also the departure of Holden. So some really important stuff too that he covers off, and some really good insights.
So some really good points. Let's jump into it.
Now, this is a really important episode because it covers the legal side of things. If you need any further information on this or any other podcasts or any other subjects you want us to cover, please reach out to either John Sinclair or myself, Mark Palavestra, on LinkedIn. Please make sure that you update and subscribe to the show below, and also like us on YouTube, but also like us on LinkedIn. And if you want to explore any sponsorship opportunities, please reach out, as we're happy to work with you.
Paul, good morning and welcome to the show. It's great to have you speaking to us this morning. So Paul, you're a director at Macpherson Kelley. You've been there for 27 years. And what's interesting, you also have a background in mechanical engineering and RT. So that's quite an interesting background to support your expertise in law.
That's right. I was an engineer first and then did a law degree on the side. And then thought I'll go and become a lawyer for a couple of years and go back to the real world, and never went back. I love the sort of the law, more the client engagement. You know, I'm dealing with people who make things and do things, and that's who my client base are. They sell things, and so it gets I suppose that side of my brain engaged and thinking along, and I can help them with their businesses and give them the legal issues and legal solutions they can employ in what they do.
Paul, you've got a broad expertise in commercial RP matters. You have particular expertise in RP protection, enforcement and licensing, also competition and consumer law, product standards, safety and recall, trade, distribution, franchising contracts, manufacturing and importing, personal property security. So pretty broad range of expertise. You also have substantial experience in automotive OEM, aftermarket and dealers. And I think that's what we're going to be talking to you this morning, and really interesting for us. And you also represent a number of brands, their dealer councils. You've been a long time in the business and pretty well experienced in this part of the field.
Yeah, that's right. I suppose in terms of all those areas of law, they all tie back to products and sales and distribution. There's protection of IP at the front end, or it's sales, distribution, franchising on the way through. That's the nature of who my client base is. And within that sits a lot of people who make stuff for, or in the older days, automotive manufacturers in Australia, the deal of networks as well. So yeah, I've always been involved in people actually do things in retail and trade and manufacturing, and a fair portion of that's the automotive sector.
Well, Paul, I'm just keen to start, I suppose, with the first question, because you've got a very extensive background with us, say, in the law, but with that engineering twist as well, and just the whole supply chain that's involved in auto manufacture and distribution. Now, I'm keen to get your understanding of the franchise code, being an expert, and also the challenges around that, specifically with automotive, and also the reasons why there was the need for a Royal Commission into the franchising code.
Yeah, so taking a step back, I suppose, the code's been in place for probably 20 odd years, I suppose, in terms of being there. It's been reviewed a few times over the period. But what it's trying to do is give franchisees, so those who take on the rights to sell something else as goods or services, probably three things. One is information, so disclosure around what the business is, what it entails, experience of the franchisor, so they can make an informed decision about who they're going to get in business with. The code also then does have some impacts on the franchise agreement. It imposes certain terms that must be there, so calling off periods, mediation, limited grounds of termination, and some rules around advertising funds and that sort of thing. And thirdly, it's around probably process and fairness in contracting. So it gives franchisees or those coming into it a certain period of time to get advice. You can't sign an agreement too quickly. You need to have 14 days. And also there's ongoing obligations then in terms of reporting back, updates on key changes to the franchisor, figures around marketing spend, and obligations like good faith that just sit there all the way through the relationship. And so, that was there to try and give all franchisees that education going in as protections on the way through in terms of what they do. One of the problems, I suppose, with the code is trying to solve or fix up those sort of limitations and disparity in bargaining strength for all franchises in one similar way. And, one end you've got a mowing franchise with very low expenditure, no premises, being dealt with the same way as a motor vehicle dealership. We're spending, $5-6 million on a premises fit out. You've got massive amount of capital expenditure on floor plan, and one code's trying to do both, for both areas, and so it can't, obviously protect everybody from all things at all times.
So, Paul, out of the Royal Commission, there came a whole range of recommendations. Can you share some of those recommendations and what came out of that?
Yeah, so there were 70 recommendations of all levels and all different areas and things. A few of the key ones was giving the government more, I suppose, say in how franchising develops and how it's also enforced. So that's sort of two aspects. One is setting up a franchising task force where effectively representatives from Treasury, from Department of Jobs and also the ACCC would help manage and roll through some of these changes and recommendations. And then there's also enhancements in terms of disclosures, more information around capital expenditure, more information for franchisees who are buying existing franchise, to get financial information from the exiting franchisee. More transparency around supplier rebates, so where franchisors who either sell to the franchisees or they negotiate the terms from suppliers, they take a kickback, I suppose, or a rebate or discount or some sort of payment, how those things are being spent and being shared or not. Some more rights and recommendations around exit rights and goodwill on termination or goodwill on expiry. It's always been a very contentious issue, whether franchises comes to an end or whether there's some payment back to the franchisee. And also some more penalties higher penalties recommended to the ACCC to enforce compliance with the code and obligations that sit within the code.
The ACCC, I'm very keen to get your understanding of how the ACCC fits in with the franchising code. And also you mentioned the disclosure and disclosure documents. Yeah. Are they the two interlinked? Is there a tie-in between the ACCC and also the disclosure documents?
There hasn't been directly. There's certainly some new powers to ACCC to ask for and check franchisors' documents, and they've been doing that fairly heavily over the last probably 6 or so months, I guess. But in terms of the ACCC, their main role is to manage and I suppose enforce, educate and take action when they need to over the Competition and Consumer Act. So that's the competition side being, fair practices around, price fixing, resale price maintenance, those sort of competition issues. And then consumer side is everything from consumer guarantees, unconscionable conduct, unfair terms, product safety, and that sort of thing. Where the code fits into that is the code is a industry code that sits underneath the Act, the CCA, the Competition Consumer Act. And so it becomes effectively adopted into the Act as part of, as an industry code. And so the ACCC with their enforcement and also education role also then enforce and educate around the code and then everything entails. So as I said before, it can call for documents and check them off and make sure they comply with the code technically in terms of the contents. They'll also go beyond that and look at marketing materials, other things that franchisors put out there, and make sure that the information in the disclosure documents match up with what they're saying or what they're doing in reality. When there's disputes, there can be complaints raised by franchisees to the ACCC, and the ACCC can then step in and seek to not run the complaint necessarily, but get involved with that complaint. They can make inquiries. They can use some of their other powers to compel evidence being produced in a pre-litigation stage. They can impose fines for minor breaches, or sometimes they have taken action on behalf of franchisees where the franchisees haven't had the money to run a case. The ACCC will step in there and run the case as a prosecution of the franchisor in what they've been doing. Often that's been around code breaches, misleading conduct, unconscionable conduct, those types of issues.
Paul, there were 70 recommendations came out of the Royal Commission. Now, there have been some changes made to the franchise code. Can you share with us, can you discuss some of those changes and that, especially around notice periods and obligation to winding down? Can you talk us through some of those changes?
Yep. Effectively, there were some changes that were mooted to come into play, I think in September, October this year. But then with COVID coming in, and these were therefore purely for motor vehicle dealerships to give them some better balance, I suppose, in the bargaining disparity between the manufacturers, OEMs, and the dealers. And those were brought forward, probably pushed, I suppose, partly by COVID and the massive drop-off the dealers saw in their sales. And those have been in place since 1st of June this year. And they cover three main areas that are there to probably protect or help dealers in owning their dealerships. So the first of those was around end-of-term obligations. So under the code previously, franchisors must tell their franchisees at least 6 months before the end of the term whether or not they have a right to renew, whether if there's no right to renew, whether the franchisor will still give them a new agreement, or whether the franchisor has decided that because there's no option to renew, they've decided to not offer a renewal term. There's only 6 months out. So you think about a motor car dealer with a massive premises, a long lease, big floor plan, lots of stock. 6 months is not enough time to plan if the dealership's being pulled away from them. So that's been extended up to 12 months now before the end of the agreement. So it gives the franchisee, the dealer, more time to work out what they're going to do. Do they have a renewal being offered, or if not, they've got 12 months to sort themselves out. And that might be winding down that dealership completely. It might be looking for other brands to pick up instead of the one that's expiring. It might be just opening up a discussion with the franchisor to say, why? Is it you don't like me as a dealer anymore for whatever reason? If so, would you like somebody else to take over my business and sell the business? It might be a plan by the car companies to just reduce their footprints and cut back on dealers. But at least with 12 months there, you have more knowledge and more time to plan your exit and do that in a way that's going to either maximise profit or minimise expense on doing it. That's the 12-month change.
So, Paul, just a question around, so is there any requirements for capital expenditure and the level of investment that franchisees and franchisors need to have in the arrangement? Is there any scope around that?
No, there's no limits on it. It's just about disclosure about what's expected, what's coming up is what's been in the code to a point. It's been ramped up now where there's changes for dealers as well. So effectively, it's really about transparency to dealers. So they know in a better way now if the franchisor has an intention to require them to spend a lot of money on their dealerships, whether it's a refit, moving somewhere else. And it's about the amount, the timing, and the nature of that expenditure as well. And that's sort of there's an ongoing obligation. But more so, I suppose, when you're signing up to a new agreement, you know what you're up for in advance, if that's the current intent of the dealership, the franchisor. If there's no intent, though, there's nothing to disclose. So it may well be the agreement says that you're required to, at our reasonable discretion, to do a refit of the premises within the next 5 years. If there's an intent on signing that it's going to happen in 3 years' time, they must disclose then when, how much, what sort of change there is. If there's no intent, just a general obligation, nothing to disclose, and therefore you might come along in 2 years' time and then be told in the next 12 months you've got to spend $3 or $4 million to update your premises. So while it's about transparency, it's not perfect, the change, and there's nothing in there about compensation either. So even though you might spend a lot of money on your refit, there's nothing in the code that requires a payment back if the thing comes to an end before your investment's been repaid to you.
Right. And just I was keen to ask the question, the last one, which is a very hot one, is what's the situation around multi-franchise? Because often the multi-franchise question, I think it's coming up to a topic we'll talk about a bit later, re Holden, but a lot of franchises, and I've been involved in a number of franchises where you don't want a competitive franchise, your dealer to have a competitive franchise either next to you or part of the site. What are the limitations or protection around that?
Not a lot. It just comes down to negotiation, really, as to what the car companies, will or won't permit you to do. But I mean, it's been a bit of a funny one in that there's the contractual rules, and they're usually pretty narrow to try and prevent it. Then there's also then just the relationship piece as well. And so while you may not technically breach the limitations of having a multi-franchise site, if your site is easily broken into two, or it's side by side into sort of different buildings, then you're not breaching the clauses of the agreement, but you still are going against probably the understood restrictions that a franchisor might want to impose on you. We saw it a bit going back a few years where some car companies didn't want to have certain other car companies in the same vicinity. Often it was about not so much competing cars, but more just brands they thought as being that would bring down their reputation. So having a more prestige brand trying to say you can't have a cheaper brand next door or a certain geographic manufacturing brand nearby. We didn't want to take ourselves that way. Or they might have felt there might have been a blur or a loss of what they saw as being confidential to their franchise, a bit of a drain of knowledge into the other newer players coming into the marketplace. That was often not contractually bound, but more so a expectation or something. What the code changes have done is not so much about multi-brand, I suppose, in terms of that type of issue, is it does permit different franchisees from joining together to negotiate as a group against franchisors. And so rather than being a one-on-one where you've got a massive disparity in bargaining strength, you can have a negotiation on behalf of many dealers as a group with the franchisors. We've seen that anyway for some of the good car companies that engage well with their dealer councils. And so I've done a fair bit of work with quite a few of the councils where we were called in to sort of negotiate the new version of the agreements that are going to be rolled out in the system. And while dealers can still negotiate case by case their own certain circumstances, what it did was got the agreement to a point that was fairly reasonable and balanced as an approach, because the council had put into their views of some of the more contentious issues and negotiated those down. So what the car company could then do to the dealer to say, look, here's our new agreement, but it has been through the council. They've had a lot of time to negotiate, change things and do whatever else. They're reasonably happy with it. We give it to you now as a dealer to look at in your own circumstances. So it starts the that negotiation at a much better, more fair footing because the council's been involved. So that's not new. The better car companies did that and engaged well with dealerships, councils. Some just ignore them, but other ones just rolled out things as they saw fit. But at least with the new changes, dealers can lawfully get together and negotiate as a group.
Paul, there's been a lot of changes in terms of the key penalties and infringements and that can be implemented for breaches of the franchise code. Can you talk around that and what sort of the changes have been that OEMs and dealers need to be aware of?
Yeah, so when the code first came out until recently, there were no direct penalties for failure to comply. The way I suppose you would be brought to task would be if through giving a non-compliant disclosure document, you're being misleading, then the misleading conduct parts of the Competition and Consumer Act and in particular the consumer law would come into play. So you wouldn't necessarily be penalised for breaching the code, but you might be penalised for engaging in misleading conduct. Similarly too, if you engaged with your dealers either as a group or individually in a very unfair way, the unfair terms regime would come in, or if you're beyond unfair into unconscionable conduct, again, you could be fined for doing that. The code was changed though last sort of rollback, and so it did impose penalties for breach of code. So it might be that you haven't disclosed something under Section 25, whatever it might be, or you didn't engage fairly, or you didn't get something done in time. Your notice period for you 12 months or 6 months prior to it, and those can attract penalties of about $66,000 for each contravention that are done. The recommendations, though, from the recent review, though, has sought to ramp up those fines to give them the same level of fines that would attract consumer law breaches. So $10 million fines for misleading conduct or unconscionable conduct, they're the level they're pushing for under the recommendations under the review. So that gives obviously a lot more teeth to the code as well.
Now that leads into another really, I think, a very topical area, and it's this concept of acting in good faith. And you mentioned a couple of terms there that really resonate, I think, for the industry.
Yeah.
It is good faith, and then there's that misleading and deceptive conduct. And the other one is unconscionable conduct. So I think getting back to what is good faith and the obligations around that, and then what are those other areas that you mentioned, and how would you define and give us probably a couple of examples of?
Yeah, probably easy one is probably misleading conduct. Effectively, everything you say, do, or can even don't say that misleads somebody or deceives them into thinking one thing when you actually either by avoidance or by taking them the wrong way, telling them something else. So, that's probably the most litigated bit of legislation in the whole of Australia, because anytime you have a dispute between two parties, someone's going to say, I thought this, you said that, I was led to believe this, that's why there's a dispute. So it's always going to be thrown up there as being a part of the claim. And in terms of the context of franchising or dealerships, often it's about promises that are made or things that are said, look, we won't do that, or we will do this, and then they change their mind, or they go ahead and do it anyway. Or the information they put in the disclosure document isn't true or it's not correct. So again, that can be misleading. So if you look at the example of a dealership, we've had quite a few cases where a dealer will come along and say to the car company, look, my lease is up for renewal. I'm about to sign up a 5-year lease or a 10-year lease. Will you guarantee me tenure of my dealership? And they say, yeah, no worries at all. That's fine. Sign up. Dealer goes and signs up. 2 or 3 years later, the dealership comes to an end and they say, where's my renewal? And the car company says, oh, look, I've changed my mind, or I never said that. I never promised that. All of a sudden, I've got a long-term lease with no agreement. So that will be an argument about misleading conduct, because you said, someone say, well, I was told this, I led to believe this. And so that's where that can come into play. Unconscionable conduct is probably a real step beyond fairness. There's a set of criteria, I suppose, not as prescriptive lists of things can be unconscionable in the Act, but indications of what might be. And it might be things like bullying in the relationship, really ramping home your bargaining strength, getting a deal that's just too sharp, too unfair on somebody. They've got no choice but to sign up to it. It might be dealing with somebody differently to somebody else or the group as a whole because of an ulterior motive, or no commercial backing is what you're doing. You just want to do it anyway because you don't like them, sort of thing. Can be unconscionable. It could be enforcing a term of an agreement that is the penalty is so out of proportion to the conduct, it's just not fair in that respect. So if somebody is slow in payment and they haven't paid a $50 debt or something, they get terminated for that. The termination, the impact isn't in proportion to the failure in the first place. That can be unconscionable as well. That usually requires a pretty egregious set of actions by one party to achieve that high bar of unconscionability. Good faith, though, is a different one. It's probably a lower level than, or it is a lower level than unconscionable conduct. And what the code there says is that each party must show good faith in the relationship and in relation to the code itself. And that's not just how they operate during the course of the agreement, but also in signing up in the first place as well, and then in termination at the end. So it's an ongoing obligation through the whole relationship before it starts right through to when it ends. And the code says that it doesn't define what it means. It just says that good faith is what it is under the common law. And so there's been a fair few cases around what is good faith. It's not clear cut. And it's always arguable as to whether something strays over the line or not. And it also does say in the code, though, it gives the court's direction, and does say that courts have regard to or consider whether the party who's been complained about acted honestly and not arbitrarily in the relationship with the other party. So honestly would be, truthfully and not lying and acting in a way that is, it can be proven, I suppose, as being their intent, properly based, not misleading, those types of issues, and not arbitrarily. So again, it ties the conduct back to probably two things. One would be some commercial basis in what they're doing or what they're trying to enforce. So there's a real reason for doing what they're trying to do. And equally too, I think it's the second one probably is around dealing with that franchisee consistently with other franchisees in the group. They're not being singled out in a way that's different from everybody else. So that might be around setting KPIs and targets. If they treat all franchisees similarly as to how they set the KPIs and targets, that wouldn't be arbitrary. If they've got a bent against one franchisee and set a target twice as much as anybody else, one, there'd be no commercial basis for that, and two, it would probably be arbitrary in terms of that impact. And the second indication of good faith is around how the party operates and conducts themselves to achieve the purposes of the agreement. So it brings the conduct back to what are we trying to achieve here under the broader view of the franchise agreement, and is what we're trying to impose here furthering those intentions. So again, it might be that the conduct is consistent with the benefits of the franchise or the purposes of the franchise. It gets hard to give examples in that one unless looking at the context of what's being done, why it's being done, is a commercial underlying purpose to this. And if those things aren't present, so, if, the franchisor was acting, arbitrarily, dishonestly, there's motives there that aren't necessarily furthering the purposes of the agreement, that could all be indications of lack of good faith.
And another question around that, because this often comes up, and you hear feedback from stories out in the networks about sometimes it's a deal done for one dealer but not another dealer. How does that sit in the broader scheme of acting in good faith and unconscionable conduct?
Yeah, probably unconscionable conduct in terms of a singular deal, because it's really about the impact on the other person who didn't get that same deal. If you treat them fairly still, it can't be unconscionable, even though the other guy may have got a better deal for whatever reason. And there's usually, often there's reasons there. And it might be that that other person did invest, 2 years ago, where the other one invested 5 years ago in premises. So there might be some reason why they got a better deal. Unconscionable kind of play goes more to the way you deal with that other person themselves in isolation of the special deals of somebody else. But if every dealer is getting a special deal apart from that one, that might be different. Like that might be treating that other one differently, and that might be unconscionable or showing a lack of good faith. I still think there's scope to do deals with car companies. Then be careful, I suppose, that the deal they give to someone or don't give to somebody else still sits within the ambit of the agreement and within its purposes. The fact that somebody else got a better deal doesn't necessarily change the impact on the other dealers generally. And if those have still been dealt with in accordance with the terms of the agreement that are still progressing the intention of the agreement, then you probably could say that's being unfair to the other people. Often it comes down to, I suppose, are the franchisors putting in place commercial strategies and decisions and then following them through in the dealership? Yes, they might have repercussions on some dealers, but if those strategies are commercially sound in terms of their decision-making to choose them in the first place, they're unlikely to be unfair or unconscionable because they're being imposed across the board, they're being imposed for the right reasons. They might not work out at the end of the day, but if the decision-making process is correct, not all business decisions work, I suppose, but that's usually the saving grace to an argument against a franchisor for acting unfairly. If they're just saying, well, no, here's our rationale for those decisions, we roll it out, didn't work or did impact some franchisees adversely, that probably couldn't be found to be unfair or in lack of good faith. You might recall a couple of years ago there was the case against Pizza Hut by lots of their franchisees. There was the price war between Domino's and Pizza Hut for the fixed price, really cheap pizzas. And to compete with Domino's, Pizza Hut put in place a value strategy where they effectively did a very low cost pizza, lower range as well for those low ones, and required all their franchisees to offer it. And that did impact some franchisees really adversely. They're selling pizzas well below cost losing a lot of money. And a lot of franchisees, and one in particular who was sort of like the test case, ran an action against Pizza Hut and lost effectively in that case. The first judge in that case said, well, yes, it did result in losses, and the franchisor was required to act in good faith and reasonably in decision making. But the judge did find, though, that the rationale for that was to compete with Domino's, and the price points, limited pizza rolls, ranges of things, did try and do that on a basis that was commercially prudent and decided. Yes, it didn't work for many franchisees, but it wasn't about the outcome. It was about the decision-making process and the implementation. That was appealed because they obviously lost. Picked up on that case and lost. And on appeal, the franchisee did actually acknowledge that it wasn't lack of good faith. They conceded that point. It was good faith. Then tried to argue reasonableness of the of that value strategy, and the appeal court said you can't really sort of take those things apart and say it's one obligation and the second obligation of reasonableness. They are sort of tied together a bit. And what the court said there was you need to sort of show almost a negative, in terms of that there was the decision was capricious or dishonest, unconscionable or arbitrary, or not a motive that was trying to drive forward the purposes of the franchise agreement. And when there were good motive, decision-making processes in place, considerations of these decisions, then that was reasonable and in good faith. So it's not an easy one to run, I suppose, when there is that proper approach to running a business. It's easy to see when it's absent, I guess, but when it's part of a bigger decision, then I suppose good faith is harder to make out.
Paul, a question for me is we've started to see a couple of brands looking at different types of distribution models, and specifically agency. Yeah. Can you maybe explain the different types of distribution models? What are the implications for dealers and OEMs in having a look at those different models? What should they be looking out for, and what are the challenges of the different types of models?
Yeah. Well, the standard one, I suppose, it's always been in place, is that one of a dealership, which effectively is deemed to be a franchise under the code, even though it wouldn't satisfy necessarily the franchise definition, because often there's no payments being made by dealers for the right. They buy the stock and it's okay, but without that payment being there, it wouldn't fall under a franchise agreement, but it's deemed to be anyway, so dealership agreements are deemed to be franchises. Outside of that one, and this is where the agency one comes in effect, the dealers at the moment, under the dealership model, buy their stock from the car companies. They hold it on floor plan and they sell it as their own car to the consumers. So it's a distribution model that falls within that franchise definition. And so they effectively have control of their pricing, whether it's the way they sell the car, the markups they make on that one, that's within their control. They've got more flexibility around, I suppose, stock to hold. I mean, there's limits in the agreements and minimum levels and things, but ultimately they can control whether they want to have more stock. They can control whether they want to have discounts, what their margins are. They can do deals with customers on fleet, whatever it might be. That's within their control because they're buying the cars and selling the cars. And the car companies can't set a minimum price below which dealers can't sell. Dealers can always do what they want in that price discounting. What the agency model does is take away the buying and selling relationship, and effectively the dealers are appointed as agents to sell on behalf of the car companies. So ultimately the consumer buys the car from the car company directly, and the dealer is the person, I suppose, who assists in that sale process. They don't sell the car in their own name, it's sold by the car company. So effectively the car company controls the price and the car company controls what the dealers get paid. They don't get paid a margin, they get paid a commission effectively for that sale. And so what it means is the car companies can then, across the whole network of agents now, control their own pricing. So at one level, they can potentially maintain a stronger margin for their cars because they effectively have no discounting of their models because they control the price. And that's taken away from the dealerships. And in reality, that's true. They can say, this car's worth X dollars and we will never sell a car for less than a certain price. And so anyone who buys a car knows or soon finds out, no matter who they go to, that's the price that's being offered to them for that car. And so it takes away competition between dealers of the same brand. It doesn't take away competition, though, between different brands. So effectively, they're still constrained, between other car companies and other models and things that are offered to customers. But within that brand, though, they can control the pricing. What it means for dealers, though, is that they become less valuable in the supply chain. And I suppose, they're less valuable to themselves because they can't control their own markups and their own margins. They've got their say in that. So it's harder for them to manage the businesses. And, in terms of some dealers like to have a higher price but lower volumes, and that's their model. They can charge more because they've got a loyal customer base. It comes back to them. They have a stronger retention maybe. They might be very strong in terms of that changeover and be very good at that, so they can charge more because the customer base is more loyal. Other dealers take a model of having low price, high volume, and that's their model, even within the same brands. That choice is gone from the dealers now, so they're sort of constrained in terms of what and how they can sell in that respect. And I suppose in terms of dealers, often that choice of how they sell their cars and the price points they pick can often be dictated by the demographics of where they are. In certain areas of the country, you've got more affluent suburbs. Loyalty, the price is not so important. In the lower affluent areas, it's about volume and price, and so that's their model. Not too sure how that agency model will play out if they're trying to keep a price point consistent across the whole of the city or the country, when you've got different impacts from the different customer bases in the PMAs of the dealerships. And I suppose too, as I said before, the dealers become less valuable to the car companies because they're not buying the cars; they're just purely a sales assistant in the process. And so, whether it's this dealer or that dealer, probably less constrained, I suppose, and less dependent upon dealers who are stronger in their customer base because it becomes the customer base of the car company, not the customer base of the dealer. They've got the direct relationship a lot with the consumers because that's who's selling the car to them.
Now, Paul, a question around that, with agency. So you raise a very good point that there's variations with the socioeconomic segments of pricing, even within the same brand.
Yeah.
So would it be fair to say that with agency, it has to be the same price for everybody? Could a OEM set a different price for one geographic area versus another and have that agent sell at a lower price versus this agent if their margins are still going to be the same? Is that unconscionable?
No, they can do that. I mean, the price is up to them to have it, how they want to set it. I suppose while you can do it, you might question why, in that one of the rationales the car companies have been given to the agency model is around price control. And so on one hand, why adopt this model, price control, and then give it away again? So maybe there is going to be bounds within that price control intention to have some flexibility there, but it'll be a lot less than it was with car companies, also with dealers competing with each other. It wouldn't be unconscionable, no, because it ultimately, I suppose what you sign up to in terms of your commission will be set for your dealership. That's a commercial decision you make when you sign up in the first place. All they're doing then is effectively paying you the commission based on the price that they choose, and you've agreed to that. So I couldn't see that as being unconscionable or unfair. Like I said before, it's based on probably based on a demographic model or financial modelling of pricing. So from that point of view, they're just rolling through what they want to achieve in terms of their market control.
That's always been one issue from a pricing perspective. When you go state by state, the on-road costs are different. So the manufacturers usually have to subsidise each state differently to achieve a national drive-away price. So this would negate all of that, I'm assuming, that it just becomes a one-price-fits-all?
Yeah, I don't know, I suppose. The states will always have different levels of, taxes and whatever else, stamp duty and that sort of thing. So I suppose there is always that potential that whatever price they might pick as being the list price, I guess, will be different drive away. They may try and adjust state by state as they do now. I suppose it comes down to, Yeah, it might be down to location, it might be down to just how big that disparity is. Yeah, hard to say. Well, I suppose from a model of agency or model of distribution, dealership model, that's really no different, I suppose. What you've lost, I guess, in terms of the agency model is inter-dealer competing. And so that's where the final negotiation has gone, I guess, to a point, or it's limited, I guess. It's probably where you've lost that. So from a consumer point of view, getting a deal on the day probably a lot harder, I guess, through an agency model than you will through a dealership model. I suppose some manufacturers might say, we'll still give the dealer a fair range to negotiate within, but they don't have to, and they can certainly make a narrow range or a not below price sort of thing as well. What then flows through in terms of on roads and things, I suppose if the starting point is going to be the same, yes, there'll be variations with different states, but ultimately if you're living in that state, you tend to buy your car from that state. So, you're competing against other dealers with different models in that same state anyway. So you saw the same impacts of taxes and whatever else.
Because part of the debate has always been that the market will always drive the actual price anyway. So whether the agency or franchise model, the market will drive the price down. It might just mean in the agency model, the discounting might be more focused and controlled by the manufacturer or the distributor.
Yeah.
So it's interesting to see where it will go, what impact it will have on margins and pricing.
Yeah. I mean, it's been adopted by a few car companies already in New Zealand. I think Toyota and Honda have both been there 2 or 3 years each with the agency model. I've not heard a lot about the repercussions from that, whether it's changed too much in their marketplace. Maybe it'll be a small market to see much, and probably less competitive market than Australia is. Honda have announced that, or they're doing that at the moment in Australia. So we'll see how that plays through. But again, there's still going to be inter-brand competition. So unless your car's, the only type of car in Australia and everyone wants it, then you're still competing with other alternative brands anyway. And I think with Australia being as it is, we haven't got the Fords and Holdens anymore that are the national icon car. It's just commodity to a large extent in Australia now. So there will be very strong competitive forces, I think, between brands. Whether you buy a Jeep or a Toyota or whatever, consumers will choose between brands a lot more than they have done in the past. Brand loyalty won't be as strong as it has been. So there will be that inter-brand competition. And I think too, I suppose, maybe even with COVID as well, consumers are more keen or more open to shopping online. And so again, without the dealership experience of going in and being looked after by somebody who you then sort of have an affinity for to buy the car from that particular brand, they'll probably choose much more on price and function, I guess, more so than relationship and that sort of affinity with people. We're seeing that in commodity goods. Cars are becoming more and more like that, I suppose, in terms of consumer sentiment as well. I mean, you've even got the couple of examples where the Subaru, was it the BRZ or the Toyota 86, I think was sold online completely by the car companies. So the whole range was sold out online. So again, that's another model I suppose people can look at, just buying a car almost sight unseen just from the specs and the pictures. So that's going to again shift consumer preferences, I suppose, and start to change the way people think about cars. Prices are cheaper, of course. Finance is very cheap. So again, it becomes a much more everyday purchase, I suppose, than it has been in the past.
It's an interesting one. Now, I came to ask a question around the dealer agreements or franchise agreements.
Yep.
And from your perspective, what makes a good franchise agreement as far as the contract term and some of the other elements like investment in facilities, brand identity? Brand's a big thing. So what, in your view, is a good, fair franchise agreement?
I mean, there's the obvious things like tenure. It's obviously probably the most important one because especially in dealership land, they're very big investments. And so you want a long-term tenure to recoup that investment. And whether it's the upfront investment or a refit halfway through, they've got big floor plans, a lot of debt, a lot of personnel, a lot of stock holdings. So again, you need to have commitment from the franchisor down to the dealership level. So they do invest in the brand, invest in their premises, invest in their people. And so you need that time to recoup that investment. So having a good period of time, in 5 years is probably a minimum, but then having clear options after that 5-year period Renewal periods, obviously, is probably the ideal one, like a 5-year term with a 5-year option, and having clear KPIs to achieve, to meet, so you get that option. So it's always guaranteed, provided you are performing in the dealership. We've seen over the last probably 10, 12 years a move away from that from the car companies. They're loath to give anything more than 5 years, no guarantees of further tenure. And that's moved from being, a 5-year term with a 5-year option to being a 5-year term with maybe a variable option based on performance, to now it's being almost 5 years and nothing else. And then we'll talk to you at the time. And if we like you and you're good and you want to stay and we want you to stay, then we'll offer you a new agreement. Otherwise, no guarantees. And I suppose with one car company or two companies moving to the agency model, if that starts to work, then the other ones will probably follow suit and then say, well, okay, that deal as you knew it is going to come to an end. Here's our new option, our new agreement for you, our agency. So it gives them that break time to change the rules after the term. So tenure is really important. Certainty around how the thing's going to run over the period of time is important too. So no clauses that enable the dealers, so the car company, to change things without, or at all full stop, or change things without some very compelling reason, and also with consideration on the impact on the dealership for those changes. So that could be anything from how they set the KPIs from year to year. It might be the stock levels. It might be the ranges they get to sell or can't sell. It might be the location where they are. As long as dealers know that things can change and things need to change, but it'll be dealt with in a fair and considered way and with plenty of notice of that change. That's probably the important thing around changing. I've got no problems with agreements allowing for change. How would you have dealt with COVID, going back 12 months? No one knew about it. So you need things to be able to change to be able to address issues that happen. And provided that the change is done in a fair way and the agreement provides for that and requires fairness and reasonableness in decision making, then that's okay. But equally too, if there's a clause in the agreement that is quite strict, you must sell X cars per quarter, or you must be open for these hours if something like COVID comes along, having other clauses saying if there are things outside your control, then you can't be held up and being breached by not complying with those types of things. COVID's the extreme example, but there's always been issues around changes in marketplaces that have impacted dealers, and they've been hung out to dry because of that. It might be that a competitors open up next door. All of a sudden, sales will obviously go down. But it's not their fault. The agreement should allow for that so they're not in breach because of things that are happening in their PMA or their region or their models. So that ability to be flexible, but be flexible in a fair way is pretty important. I suppose the other thing is just that understanding of the big spends over the course of the agreement. Whether it's a rebrand, whether it's a full whole premises rebuild, whatever it might be, or a new lease being signed up, knowing what to expect before you sign up to it and having people notice of that. And probably the ability to walk away if you don't like it. Often you're stuck in the agreement for the 5 years. You're required to spend $1 million on a rebrand. Or it could be $3 or $4 million on a rebuild. You can't walk away from that agreement generally. So having the right to walk away could be a good one if you don't like that level of decision. It may not be the best for your business to terminate, but it might be better than the alternative of spending all the money with no guarantees. And maybe then there's a bit of balance there. The dealer then goes, well, okay, I'm happy to walk. Then the decision for the car company is, do you want to lose that dealer or do we give him more time rather than 2-year guarantee, or give him a new agreement for 5 more years after that spend's been made? So that point of view, it gives you maybe a bit more balance in the negotiation.
So, Paul, do dealers actually get pursued by the OEMs if they choose to walk away?
Yeah, certainly. I mean, the way most dealership agreements work is effectively you're committing to them for 5 years, and if you try to break away, then you've breached the agreement. And many actions have been brought for dealers, one, to stop them doing that because they don't want to lose that site to another brand. It can be one of the reasons why they get sued, or it could be the loss of sales from that area because that dealer's now gone with somebody else. So that could be let's say you're 3 years into a 5-year agreement. If you're selling 200 cars a year, you're making X dollars for the car company, plus then all servicing everything else and parts. you effectively lost them 2 years worth of that income. That's what you get sued for. So, if it's $1,000 a car being made by the car company, what's that, $2 million of lost sales. Add onto that your servicing and your parts and things. It's a fair bit of damage that you're causing by walking away early. And yes, there's a obligation to mitigate by the car company to try and minimise the exposure, and there might be some pushing customers to other dealers nearby, might be granting a new dealership. There'll always be a drop between the person leaving and the new car company coming on board, or the new sales coming in, or whatever it might be. So it's a pretty big stick they've got to wield if someone tries to walk away.
So, Paul, we've seen some brands leave the Australian market fairly recently. We saw Opel pull out of the market. We've now seen GM Holden leave the market.
Yeah.
Do you think there's any learnings we could take from that? Looking at what's happened?
Yeah, Opel's an interesting one because it seemed to be a lot less contentious. Obviously, it's not a brand; it's an Australian icon. But just the way they went about it, maybe because I suppose it was a newer brand, didn't last very long, and I guess the deals were paid out to numbers they were happy with, reasonably happy with, I guess. So there wasn't a lot of angst around the Opel one leaving when it pulled out. And dealers, I suppose, hadn't been there for a long time. They could swap over into something else if they needed to, because it was sort of an add-on brand for their dealerships. Most of the Opel dealers had GM already with Holden. They had probably 3 or 4 different brands. It wasn't a big impost for them to roll one out and roll a new one in. There was a fair bit of notice period for that. Whereas Holden's a bit different in that there are a lot of deals for Holden, and that's all they've got. Yes, they're multi-brand ones, and obviously the big AHGs and whatever else, but a lot of livelihoods were tied around the Holden brand for 20, 30, 50 years of the family business, and that was a lot different to the Opel one. The thing I find the most interesting, I suppose, about the Holden pull-out was, in reality, these dealers were they locked in for 5 years or whatever their terms were, and they had 2 or 3 years to go. And it was purely a convenience by Holden to walk away early, and draw the line and breach the agreements. And really, they're in breach of their agreement. They're required for the 5 years to supply the cars, and they're terminating for convenience, effectively. They've probably done their sums and worked out, well, we can get away earlier, not support the brand for the next 2.5, 3 years, bring new models in and whatever else, and then end them properly, or we can bring it forward, pay out money, and walk away earlier. So, that doesn't sit well with me in terms of if you sign a contract, you need to live up to it. They've not done that, but that's their choice. Then it comes into the point of negotiating the out with the dealers who've had their agreements breached, and obviously then people looking at the code to try and protect them, and the code didn't do much about that because it doesn't cater for termination for convenience. I guess it's about disclosures, it's about protections for dealers signing up, protections for dealers on the way through, but not out of the ordinary sort of termination. So it came down to negotiation. And even though the dealers were allowed to bandy together and negotiate as a group, a lot of them are still very unhappy with the deal that was done with the with GM. So I suppose the disparity that was there between GM and the dealers wasn't addressed by the fact that dealers can negotiate as a group. So I said before that one of the code changes being brought forward was enabling franchisees to negotiate as a group. It didn't work that well, I suppose, in this situation for a lot of dealers. I mean, maybe it did, I don't know, but my take on it didn't. If the dealers dealt with them case by case, maybe they would have been even worse off. So maybe having a group did get a better result. But, certainly the feeling around is that they're not very happy with the deal that was done, and they sort of were pushed to a deadline, and most of them caved in and signed up to that deal. I mean, to be fair on GM, I suppose the alternative would be they roll out the agreement for the next 2.5 years. Consumers know they're walking away in the end of the period. Car sales drop anyway, so maybe end of the day the dealers may have got more than they otherwise would have got. None of them are going to know that, but that's probably the unknowns that you just bounce up in terms of how you approach a walk away during a term of an agreement. So it's a funny one, that one, in that you never know the alternative because it's never going to happen. You can probably go off the sentiment, but I don't know. Yeah.
But Paul, is there anything that current OEMs and dealers and that should take from that? And should they make any changes to their contracts as a result of that? Or is it just something that's extraordinary that maybe won't happen again?
I think from a dealer point of view, you've always got to be sort of mindful that a contract isn't sacrosanct. This has obviously been a very public withdrawal from GM. And, once one car company does it, gets away with it or gets out on certain terms, others will know that and then look at it and think, well, that's an option for us now if we want to do it too. And so, it's a big move for GM to do it. And there's a big risk for them to do it as well. But now they've sort of come through it, others can put it in their kit bag of options for them if they want to do the same sort of thing. And so they know it's on the table because, GM did it and got away on those terms. And so from a dealer point of view, you've always got to have that sort of niggling doubt that commitment's not a commitment for the full time. So I reckon what you will need to do is if there are those requests for big spends or things that are going to cause you a lot of cost and effort, new leases or whatever else, you do a deal with, or a very strong side deal with the manufacturer about that spend, so that if there is a change of mind for the group as a whole, you've got something to negotiate at a better level because of that promise that was given to you the year earlier, or whatever it might be. So it might be a commitment you're seeking to say, well, before you move premises, before you build this, we want to have some sort of term in our agreement about this rebuild that if you pull out in 2 years or the thing comes to an end, other than through our fault, you will pay us back X dollars as compensation. So that way it's sort of locked in for your special deal. So I think that those sort of side deals are probably more frequent, or should be more frequent from a dealer point of view, because that they've got to have that mindset of all the alternatives that are in play there. And it's one more alternative, one more issue to bear in mind when they commit to a spend.
Because it is amazing. I'm a 17-year GM, 2-year Holden dealer team before that, veteran. So a lot of time with the brand, and it has, for me, it's still unthinkable that this has happened. And I can understand why a lot of dealers would be shocked to think, well, hang on, how the hell does Holden or General Motors pull out of Australia when, it was the Australian car?
Yeah.
So do you think that there will be clauses written into contracts going forward that dealer councils will be pushing for this, that there is now, a clause for COVID potentially and a clause for departure? Because no one would have ever thought that Holden would pull out of Australia. It's just, I still can't understand it. I can, but I just think it's just so surprising if you look back to 1998 through to 2003. Monaro, game over, all this sort of stuff. And we're now at this situation where the brand is leaving or almost left. So will those clauses be now, can you see dealer councils pushing for those clauses to be put in black and white in the contracts?
They certainly should be asking for them and pushing for them. Whether they get them or not is another question, I guess. I think the COVID clause much easier to negotiate, because it works both ways for COVID as well. It's not just a one-way street. Car companies want to push more cars, but they're constrained by supply chain themselves as well. So that can help both parties, which foot the shoes on. The early termination one, it's hard to negotiate and hard to sort of document that because it's a breach of agreement. So no matter what terms you have, if they're going to breach, they're going to breach. What you might be able to negotiate would be, I suppose, what would you negotiate? That you'd have to almost negotiate in the right to walk away early and then put a compensation payment on the flip side of doing that. But then you're opening up the door to a permitted walk away during the term of the agreement. So that's a big call from a dealership council point of view, giving the car company the automatic out, and then try to negotiate, which is an amount that's fair for all parties, which, when it's case by case, it can't always be fair for all parties either. So you're sort of almost like you're in a rock and a hard place, asking for maybe worse than dealing with it after the event. What you probably would negotiate might be around not so much the right to walk away or the damages there, but the key problems when someone does walk away. Not in the sense of them saying you can walk away, but if you look at the impacts on the dealers, it's around the timeframes of notice in terms of how fast it happened, It was about how much, but not so much how much in terms of the loss of the sales because of the early breach, but more so those investments they've been making in their brand, in their businesses. And so you might put some wording around the investment can't be requested unless there's more notice being given about it, or there's some compensation if things do come to an end on the premises fit out or something else. Or it might be that you say there's a contribution to an investment. It's a large investment as opposed to the dealer wearing all of it. And so part of the funding is given to them by the car companies. Just different ways of dealing with a loss of the dealership, rather than saying, here's a formula to walk away early. Again, that won't necessarily be right for all dealers or any dealer. So that's probably where you angle the negotiation or the impacts then on the right to walk away.
Paul, thanks very much. I think we've covered a lot of information this morning and some fairly technical type of discussion. And I think it's really important for dealers and OEMs to understand the changes that have happened in the franchise code and what can be some of the implications of those changes. Mark, do you want to give a summary?
I'm just keen to I suppose, put some numbers, not numbers, but some points together. So for me, Paul, thank you very much for today.
My pleasure.
Obviously, your expertise has shone through well and truly, so thank you for taking the time to come on our show. For me, definitely, it's the franchising code is, and correct me if I've got this right, so it's very much about limiting the bargaining strength of one side versus the other, so it sort of evens up as much as possible. Yeah. There is, as far as the code, it's very much goodwill at how you deal with the goodwill at the end of the term, and deals with issues with the ACCC with retail price maintenance and also acting in good faith. Transparency is a big piece of it. So in the notice period, you mentioned that some were 3 months. Now it's minimum 12 months notice period. Yeah. When we look at the big issues around the misleading and deceptive conduct, they're huge issues. And what really came out for me was the need for a really good, strong dealer council and to be engaging with that communication with the OEMs and having a good relationship between the OEM and the dealer council. And once again, this transparency theme came through in the information that you're sharing. Very much what makes a good agreement is tenure. So you want to have at least 5 years with preferably another 5-year option, but obviously some clarity around that and with clear KPIs as to what it takes to maintain that franchise. Certainty on how the arrangement's going to work and how the business is going to run, but still have some flexibility around what are the operating terms. So in case a competitor turns up right next to you and impacts your ability to achieve volume, that's taken into account. And also understanding the big spend or how much the spend in investment in the franchise comes into play. So, and the last one I think was a really highlighted one that you mentioned is the walk away early clause. How it could be a good thing, it could be a bad thing, but just to be mindful of that. If there was a franchisor to depart, that there has to be a negotiated settlement at the back end of that. Yeah. Have I summarised that right?
Very much so. Yeah. The code won't solve problems necessarily, but what it should, I suppose, at one level, it should really try and give dealers the knowledge to make decisions properly. And whether that's to invest or not invest, to walk away, not to sign up, that's really their first decision. Do we do this or don't we do this? And the code, and also, I suppose, their own negotiations, that's their prime consideration. And then, I suppose, once they've done it, they've got to live with the consequences within fairness and within reason. This one, I suppose, to take home point is things do change. Personnel change in car companies a lot. And your relationship may well change from being very friendly to being one of just you're one of everybody else to being one where you've actually got an aggressive conflict going on. So it's really important that when you have decisions being made and information being given to you, that is documented. And so whether it's emails back from you to the car company saying, further to our discussion around this new lease or new premises, we discussed the following, you promised the following, this is why I'm doing what I'm doing. if that's in writing, that can be pulled out down the track if things do change. And you can say, no, I did this for these reasons. Here's the confirmation. Here's the evidence. It sets up that deal of much better negotiation for compensation if things go pear-shaped. Or you can hold the car company to account because they made those promises. If they're not in writing, you can wash them goodbye. They've never been enforceable. So if there are key things that aren't in that disclosure document that you are relying upon, get them in writing, confirm them, send them off back to the car company.
Yeah, I think that's a really good point, Paul. It's sometimes you rush to get the deal done, but you don't document every stage and every discussion. So it's quite important to do that. So
yeah.
But thank you very much. Is there anything else you want to cover? Any other topics or points you'd like to mention?
I suppose the only thing would be in terms of future looking, they've only brought forward three or so of the recommendations from the code review. There's 70 odd being made, so there will be more coming through. It'll help all franchises, I guess, not just the dealership ones. So people should keep alive and keep an eye on those ones as they roll through. And they can only be there, and all of the changes being made are for the benefit of the franchisees. So it will get better. And I think hopefully with the holding experience, some of those changes that are going to roll through might well address some of the issues that have rolled out to the dealers' detriments in that one. So hopefully the future's looking clearer, I suppose, and also a bit more strength there for the dealerships than it is at the moment.
No, thanks very much. Mark, anything else from your end?
All done for me, Paul. Thank you very much. You've actually demystified the franchising code of conduct, because I must admit I've seen the document. It's yay thick, and in many times I would look at it and go, oh my God, how do you get through all of this? But you've done a really great job, and thank you for just sharing how it all works and how smooth and streamlined it can be when everything works well. But just to be mindful of those key points that can either trip either party up, whether it be the OEM or the dealer. I was actually not aware that a dealer could be pursued for leaving. I thought the dealer could just leave for convenience and so be it. But that's something, it's key learning for me today. And thank you, Paul.
My pleasure. Thank you.
Well, an amazing episode there. Hopefully you guys enjoyed it as much as we did bringing it to you. Once again, if you like what you see, please like us below here on YouTube. Also like us on LinkedIn, and please subscribe down here as well, because we need more subscribers, and that way you'll get advice as to when we have our next episode. Look out for our next episodes. We will be posting more information on LinkedIn, but if you need to contact either John Sinclair or myself, please do via LinkedIn, and we'll respond to you with any information on feedback or any other subjects you want us to cover. And if you want to explore those sponsorship opportunities again, please let us know, because we're more than happy to work with you.
Okay, everybody, thanks for listening. Have a great day and keep safe.